Good morning and welcome to today's webinar. I'm Tom Cosgrove, Senior Vice President of Public Affairs and Knowledge Exchange here at Farm Credit East. Today's webinar is sponsored by Farm Credit East's financial services and consulting programs. And I want to make special mention of our payroll staff who are on the front lines working with our customers on the compliance for many of the rules that are going to be discussed today. And so if you have questions or want to learn more about our payroll services, please call us or check us out online. Today's webinar is going to touch on a number of federal labor topics, some of which really have a different outlook and a different context now given the change in administration, and that's something Chris is going to talk about as well. So to provide that perspective, we're fortunate today to have with us Chris Schulte, an associate with the law firm of C.J. Lake in Washington, D.C. He has degrees from Harvard and the Georgetown University Law Center, where he worked for the U.S. Attorney's Office while he was in law school. He's also clerked for appellate courts in New Hampshire and New York. Chris works on a variety of employment law matters, including wage and hour, H-2A and H-2B, as well as working on a number of policy issues with Congress and federal agencies.
Welcome, everyone. Thank you for joining us. So here we are. So we had talked about the DOL overtime rule. That now, events have overtaken that. That's a thing of the past, along with a number of other things. We're coming up on 4 weeks into the new Trump administration, slightly longer for the new Congress, who were sworn in just after the new year. They're already hard at work, kind of pushing on new laws, repealing old rules, basically rolling back a lot of the changes that we'd seen in the last 8 years before this. But as people start to look forward, we try to figure out essentially what it's going to mean for agricultural employers in particular. In the coming years, what's going to happen on labor and employment rules in particular, worksite enforcement, wage levels, any of the enforcement priorities that are the things that keep most employers up at night. Also on immigration enforcement. We know that anyone that's completed an I-9 process, you've looked at the documents, they seem to be valid. As far as every employer is concerned, their workforce is 100% legal. That said, in the industry in general, when people look very closely at the agricultural workforce in different parts of the country, they find that a number of the workers are not properly documented, that they've presented possibly fraudulent documents to their employers, unbeknownst to the employer, of course. But when they come through, if they were to perform essentially an E-Verify check and run them against a government database, they might not pass that test. And also we're anticipating changes to the H-2A and H-2B temporary visa worker programs in the years ahead. And then one of the highest profile things that Congress picked up immediately upon being sworn in was the repeal and replace or repair, whichever term they're using today, on the Affordable Care Act, Obamacare. So, with all of those possible changes, where does that leave us? Who knows? There are reasons to be hopeful, reasons to be concerned. We had hope and change for the last 8 years. Now we know there's going to be change, and we hope it's good. Some of looking at some of the factors going forward, President Trump won the rural vote by a 3-to-1 margin. Strong support from agriculture and small businesses. That was a loyal part of his constituency. That was part of the tipping point in some of those Midwestern states that put him over the top in the Electoral College. So we would hope that he would recognize that and there would be some loyalty to that group. On the campaign trail, there's a lot of talk about rolling back the DOL overtime rule. That's already underway. It was blocked in court, as you know, but there's an effort to just basically take that off the books altogether. There's a talk generally about removing regulations that were crushing small businesses. That's going to cover OSHA and some other worksite rules. And top priority of rolling back the Affordable Care Act and replacing that with something that works for employers and works for individuals who want coverage. On the other hand, immediately after the election, the President put out a YouTube video with his priorities for his first 100 days. Among those were calling for DOL to investigate all abuses of visa programs that undercut the American worker. That may have come as news to H-2A employers who use the program because they can't find enough American workers. By definition, that's how they're in the program. This idea that use of the H-2A is undercutting that and is finding a way to pay lower wages to hurt U.S. workers is something that has been a bit of a hobby horse for some on the far right, but is just not the reality that H-2A employers who have to write those payroll checks for the high wages would recognize. In the inaugural address, there was a big focus on Buy American. Everyone can agree with that. That's going to include produce, but also Hire American. The question is, what does that mean? I mean, where it's possible to hire Americans, obviously everyone does. Where that's not possible and people turn to visa programs, it's not clear what that will mean. And then finally, as we mentioned, the people that are surrounding the president in the West Wing and now at the Department of Justice have been, very vigorous opponents of foreign-born workers in all their various forms, people that had come into the country on improper documents, but including people working in the H-2A and H-2B legal visa programs. So, going forward, these are some of the things that ag employers need to keep on their radar, kind of as we see those changes, and there's that tug of war, frankly, within the party, kind of what that's going to mean, kind of who will end up winning out remains to be seen. That said, most of the employment laws that we deal with and most of the immigration-related laws have been on the books for decades. The Immigration and Nationality Act, which created the H-2 program, dates back to 1952. It was updated by Congress and most significantly in 1986. So we're now 30-plus years since that change. The program has remained mostly the same since then. Fair Labor Standards Act, which governs issues of overtime, minimum wage, child labor, rate, timing of pay, work days, things of that nature. Those have been on since 1938, so we're approaching the 80th anniversary of that. So those have remained essentially steady with some small changes through the rulemaking process over the years, but those have been there and are not likely to be changed dramatically going forward. And best practices for employers essentially never change, and the things that worked a year ago or 5 years ago or 15 years ago are going to work in the years coming ahead. If you have a good process of record keeping, you have a good payroll system, HR staff or payroll staff that you trust, that's your best defense if you're audited. If there's stepped up audit pressure either on the wage payment issue or on the immigration issue, having good records and good paperwork is always going to be your strongest armor, your best insurance. And essentially just knowing your rights, by participating in webinars like this, tracking these things through Farm Credit East, that's your best way to stay on top of it. There will be changes, so it requires more time every day of kind of, checking online, reading the papers, kind of staying on top of it, just to know kind of any changes in the landscape that could affect your business. Starting on wage rules, these are some of the things that essentially have not changed in quite some time. That there may be more focus on this or less focus. Under the prior administration, there was a focus on hiring additional wage and hour investigators, and there was a particular emphasis from the most recent administrator who believed that agriculture was a, quote, problem industry and needed to be targeted with additional enforcement. Any of you that are in the H-2A or H-2B program will be well familiar with wage and hour audits. Most people are audited in their first year or two, and then usually if you've not been audited for 3 or 4 years, you should probably expect one pretty soon. Other employers see it slightly less often, but agriculture in general is subject to audits at a much higher rate than than the population at large. Federal minimum wage hasn't changed in a number of years, $7.25 an hour. There's been some discussion of this on the federal level with Republicans in control of both houses. In the White House, it's not something that we're likely to see soon. The incoming labor secretary has expressed some support of it, but not up to the levels that obviously that the Democrats are talking with, $11, $15 an hour wage. It supports maybe some change in that, but not. Again, this would come through Congress, may not come soon. And then the overtime doesn't generally apply to agriculture, as we'll discuss in a little bit, but this is something that most people are familiar with, time and a half, over 40 hours a week. The real change has been at the state level. On the West Coast, we're seeing minimum wages go to $13, $15 an hour, pushing for overtime for agricultural workers as a state rule. And again, you have to meet the highest applicable rule. So The 725 federal minimum, it doesn't really apply even throughout most of New England or New York. The states, as you see here, have already put in their own rules. So this is, again, assuming that you're not in the H-2A program. The 725 doesn't help if you're in New York, where you have to pay the higher rate already. Connecticut, 1010. Massachusetts already at 11. More changes coming next year. These wages are already higher than they were 12 months ago when we would have had this talk last. On the H-2A side, those wages have jumped up in particular too. The states there are grouped together. They're surveyed together by USDA to set these wages. It jumped up by, I believe, 30 or 50 cents an hour. All of a sudden, I mean, the prices of the things that you're selling haven't necessarily kept pace with that, obviously, but the department has decided to step these up. We're up to $12.19 an hour just as a baseline for entry-level workers in H-2A in New Jersey. Throughout New England and New York, they're all grouped at $12.38 per hour. Overtime exemption, we mentioned this before. Agriculture generally is exempt. Not in all cases, as we'll discuss, but generally speaking, ag is exempt from overtime. There was talk, the rule was supposed to take effect at the beginning of December of last year. It was blocked in court before it could take effect, and now essentially is believed that it'll die in that process, that the current administration was strongly opposed to it on the campaign trail, not likely to essentially fight for it vigorously in court, and so regardless of whether they issue a new rule undoing that or just sort of let it stay blocked by the court so that the prior rule would stay in effect, the expectation is that the old salary threshold of $23,660 will stay in effect. That was the main change. The definitions of the job to be covered under that white collar or the EAP exemption didn't really change. It was really just the salary threshold was going to jump up to over $47,000. This will keep it essentially where it was. There's some other exceptions here, wait staff, computer professionals, some over-road trucking, but the main one that we're going to focus on is the agricultural. You can have more than one apply. I mean, you could have a white-collar farm manager who is an executive, somebody so they're overseeing 2 or more people with the ability to discipline, hire, fire, do the sorts of things you think of a manager doing, but the work that they're managing happens to be agricultural, so they would be what we call double exempt. Not really helpful. I mean, basically it just means that if they work 50 hours in a week, you're going to pay straight time for all those 50 hours, or if they're salaried, you'll just pay their regular salary. You won't have to worry about overtime. It's useful if one exemption is lost, then they would still be protected by the other. For example, if they're a white-collar manager, paid on a salary, but some of the workers they supervise or they themselves work on crop from another farm, or they get involved in processing or something that could potentially cost them the agricultural exemption, as we'll discuss soon, they would still be exempt because they're, at all times they were still a white-collar employee paid a salary. And again, the exemptions are, it doesn't go, even though you're a farm, some of your workers might not be exempt, and even if you have H-2A workers who are by definition agricultural, quote-unquote, they might not be doing agricultural overtime exempt work at all times. So it's possible for H-2As to be paid overtime. It's rare, but it could happen. The definitions do not entirely overlap at all times. And again, it's pay period by pay period. So it's per worker and per paycheck. So somebody could be exempt for 51 weeks a year, then not exempt because of something they did one day, which will make them not exempt for that one pay period, and then go back right to it. So it's not something that a status that they carry with them or that the business carries with them. You have to look at the work that each person does in each pay period. Primary ag is what we're familiar with, just sort of the dirt under the fingernails, kind of, weeding, watering, planting, picking, kind of the usual definition. There's an exemption that was added later. Some New England senators put in a provision that exempts cider production. Generally speaking, if you're processing the food, it may not be covered. That work may not be overtime exempt. So, cleaning things, kind of putting them into bags, putting them into packages for shipment, that's all fine. If you are in an apple orchard and you sort of you're getting it, you're taking the leaves off, kind of putting it into bags, that's fine. If you're baking it into a pie, that's no longer agriculture. It's not in its original state, and so that work would not be exempt. So there are lines like that. Cider production normally would not be exempt if it's done on the farm, but because of the language that was added in, it specifically is. And then secondary ag is where more of the litigation is involved, where it's a little bit less clear. This is more of a gray area. So these are practices that are are not necessarily specifically farming practices. You're not handling the plants or the produce, but they're done either by a farmer or by the farmer's employees or on the farm. And then this language, incident to or in conjunction with, legalese, it's sort of in the eye of the beholder, and so the idea is kind of how closely connected is that to the work of the farm. So that could be tractor maintenance. You're changing the oil on a tractor. You're not actually working with plants, but you need that tractor to do the work so that other people can plant and harvest. That would be covered, especially if, critically, if it's done on the farm, so that if you send it out to a repair shop and there's repair done elsewhere, that's potentially not ag overtime exempt, but if it's done on the farm, it could be. This comes up a lot for kind of back office staff. If you have payroll staff or managers, people that never go out into the field but write the paychecks for the people or kind of take orders for you, kind of handle things in-house. The argument is that that is incident to or in conjunction with the farming, that you couldn't operate without them. People need to be paid and you need to be able to sell your crops. That work, to the extent that it's done on the farm, the argument is that that is secondary ag, and so that they are exempt. The bottom line for all of this is that if you were exempt last year, if you've been operating, especially if you've been audited and they've not found an issue with you, but if you haven't been paying overtime to workers, there haven't been changes in these definitions for decades. So these rules are what they are right now. It's not likely that they would change it in a way to make things worse for employers, we'll say, in the near future. So if you're not paying overtime now and that's worked for you, that won't change. So for a lot of this, I mean, there's sort of, it's interesting for lawyers only. For employers, you just want to know what to pay the workers and kind of how to take care of it. So if you've been doing it and if that's been okay, don't worry about it. No need to overthink it. If it works, it works. But this is kind of the framework for what they're looking for if wage and hour came in to take a look at your payroll records. And again, we talked a little bit about this with the apple pie exemption. The idea of handling the crop in an unfinished state. I mean, that changes a little bit. Some things would need to be, that you'll see kind of bags of baby carrots, say, in the supermarket. Someone's harvested that. That's not how they come out of the ground, obviously. So there's some process to that. The question is kind of, is it in its unfinished state? That's where people kind of get into arguments sometimes with wage and hour. Basically kind of cutting things up. Something other. If you take lettuce and kind of put that into a bag and send that off to the supermarket in that form, that's maybe one thing. If you kind of cut up carrots and celery into a platter that they're going to sell there, maybe that looks more like you're preparing it. There's some point in that spectrum for when you take it off the tree, take it out of the ground, and it ends up in the supermarket, that there could be processing involved. That's that kind of gray zone of kind of what is exempt for those purposes. Essentially, in kind of anything where you're working on it kind of until the moment that you put it onto the truck to drive away, that's all fine, and then at some point it magically becomes non-agriculture during that journey and becomes retail or becomes manufacturing. And another situation where you see people running into trouble is handling other growers' crops. There's some small exceptions where there's a crop failure, one of your fields floods out and you have to fulfill a contract. It's a one-time thing. We've lost 5 acres of squash. We need to fulfill our contract. We need to buy it in just to turn it around and sell it. That's usually acceptable. The concern is if that becomes a regular part of the business, if you are packing for other growers nearby, kind of turning around crop, that wage and hour will say, well, now for those purposes, you are not a farmer. You're essentially a retailer. You're just reselling somebody else's product that you have not done the work on. That's not agriculture anymore, and so you need to pay overtime for any of the workers that touched those outside squash or apples or nursery stock that somebody else had grown, and where you just turned it around and sold it. In the nursery context, it's interesting because the plants are ongoing. They're living while you have them. So you've taken them in, you're watering them, caring for them, and then turn around to sell to customers. Then it gets into, okay, well, how long did you have it? I mean, you don't have to start every plant as a seed. They'll come in, as seedlings. You can get them in a rack, and then you will grow them into a mature plant and sell them on from there. You don't have to necessarily have started it from square one. But if you have it, basically a bush comes to you, you water it, turn it around a day or two later and sell it to somebody else, they're going to treat you more like a garden center or a wholesaler, retailer, and say, okay, anybody that did handle that plant is owed overtime because that part of the work is not agriculture for those purposes. So the devil's in the details, kind of in some of those specific cases around the margins or where you're going to see people lose that exemption. But that's kind of the big thing to keep an eye out, that again, it's specific to those workers. So if you had one crew or one person that handled it, maybe they're owed overtime, but not the entire workforce. But if wage and hour comes in, you need to be able to explain to them, these are the people that worked on it, and I know that these people didn't. And if it's a regular part of your business, if you run, say, an apple packing house, you can operate multiple lines so that all the apples that you've picked yourself right there are handled on one line. Those people are not paid overtime. And then if you have one for outside apples from your neighbors, those people would be paid overtime. Two people doing the exact same job in the same room, one exempt, one non-exempt, strange outcome, but that's the kind of thing they would want to look at, that you defined kind of who would be working on one and not the other. Sometimes people will have different ID badges, or there's some way that they track kind of which workers will do which jobs. That's the level of detail that they'll come in and audit on. Speaking of detail and audits, the twin pillars of the H-2A visa program. This is a program to legally employ foreign workers on a temporary or seasonal basis. Is used by a number of growers. I know especially in the Northeast. It's growing in the areas in the South, Deep South, and on the West Coast in particular. As the flow of migrant workers and essentially as the border has tightened up, frankly, in the last 15 years, employers in California, up the coast into Oregon and Washington, no longer have that consistent flow of workers to rely on, and so more and more they're coming into the program. So the total usage of the program is several times what it was even 5 or 10 years ago, and continues to grow every single year. Unlike the H-2B program, which has a hard visa cap, there's only 66,000 visas possible for the whole country for the whole year. H-2A has no limit, so they are, I believe the last number was 160,000 or 170,000. Depending on what happens with immigration enforcement, that number could jump and be 2 or 3 times that. There are concerns with the bandwidth, or basically the capacity for the government agencies to process that many applications in a timely manner. They've been struggling in the last few years to process even the current levels. So the idea that the same number of people at the same staffing level can do 3 times as much work in the same amount of time is frankly unlikely. So, but we'll talk about that a little bit later too. The basic highlights for the program, usually you can get workers for up to 10 months at a time. They will not allow year-round work. So most, essentially dairy production has been left out of the program almost entirely. There are some dairy orders that come through, but they need to articulate kind of how their work is limited to a 9 or 10 month part of the year, and are not just sort of, essentially the same work, because the cows don't care if it's 4th of July or Christmas morning. They need to be milked, 365. But there are some parts of dairy that, feeding them, or it's specific to calving and weaning, or there's some dairies that can operate where there's a time of the year when the cows do not need to be, milked on a regular basis. They're able to manage that, so they can bring in work, bring in H-2A workers to do that part of it. And generally speaking, they're tied to a specific farm and a specific location and a defined set of job activities. If the workers come, you can't loan them out to the farm up the road because they had somebody quit. Huge no-no. That's the kind of thing that will get people kicked out of the program. It's a debarrable offense to have them work outside the job activity, outside the job contract. Requires recruitment of U.S. workers to make sure that there's truly nobody in the area or in the wide net that's cast through the advertising program willing to take the job at that wage. Corresponding employment is that if you have U.S. workers that are doing the same job as the H-2As would, you need to give them the same benefits. So that means U.S. workers that are coming from beyond kind of a normal commuting distance. Somebody travels from Texas to your farm in Massachusetts to take a job. Somebody travels more often from Puerto Rico to come take the job. You need to offer them housing just as you would for U.S. work, for your H-2A workers rather. And they'd need to be paid those adverse effect rates that we talked about up front, the $12.19 or the $12.38 per hour. Need to provide transportation, round trip to the H-2As, and this idea of the 3/4 guarantee that, the number of hours that are listed to be offered, you need to offer them those. On a particular Northeast issue that we're seeing, the Massachusetts State Workforce Agency, or SWA, for love acronyms, and now a little bit in Maine, it will not allow H-2A employers to list kind of more hours on the job order. On the page 1 of the job contract, you list kind of how many hours you project that they'll be doing each day. Generally, people work Monday through Saturday, but they will not let you list, say, we expect that at some times of the year we're going to be doing 10 hours a day, 6 days a week. They'll say, no, we're only going to let you list it at, I believe they're capping it at 48 hours per week. Now we're seeing auditors come through from Wage and Hour and say, well, you said that they were only going to do 48 hours of work per week, but when come to find out, they're doing 60 hours a week. And they'll say, well, we know, it's harvest. This is what we need to do. We would have told them, but our state workforce agency wouldn't let us tell them this. And they said, well, that's too bad, and are assessing fines of, and it's consistently been $450. It's a very precise amount. I've already seen, I think, 3 growers in Massachusetts get hit with that. It's possible that other people will too. It's essentially a tension between the part of the Department of Labor that certifies and then the part of the department that enforces the law after the fact. They need to get on the same page, so we've been working with the offices here in D.C. to kind of get them to get that straightened out so that more people won't be stuck with that. If you do see that, my contact information right here, just let me know. There's sort of a standard letter that we send in to challenge it, and then we're hoping that we'll get it straightened out soon so that most of you will never see that. But if there's an issue with kind of what they call kind of misstating the hours to be worked, don't pay the fine right away. You have 30 days to challenge it, and we can kind of address that. But it's something that has become a little bit more prevalent in the last, say, 2 to 3 months. There's been talk lately, some of the proposals in the new Congress are ways to make the H-2A program work better. Anyone that uses it knows that it does work for them. They get the workers eventually, and they're good, reliable workers. It's costly, but it's predictable. You know generally you can get the same guys back pretty much every year. You know that they're going to be experienced and skilled workers, and so there's some predictability that comes with that and some peace of mind. That said, the program runs very slowly, and it can be very frustrating, especially this time of year when you're going through the application program to try to get the workers in the spring. Some of the changes that are in play are to go from provide housing, kind of to have to build and maintain farm worker housing on your own farm, to being able to use a housing allowance where you would give a certain amount of money, the workers could find their own apartments. A lot of workers choose to do that already. They just sort of waive the housing that you're offering. They say, I understand that I can have a bed here, but no thank you, I'm going to live with my family members that are in town, so be it. So that's one of the proposals. Some clarification on this idea of corresponding employment. As I said, it's basically that U.S. workers doing the same job would get the same pay. That's how it was always intended. It's been interpreted more recently by Wage and Hour to say if you have any U.S. worker that does any one part of that job, they're entitled to the full wage. So if you have in your job description that these are workers that are driving tractors, handling handling pesticides, doing complicated work, can identify the plants, make decisions about irrigation, kind of do fairly high-level things, even if they have, an experience requirement. They have to have 3 months on the job to be able to do this. And then you have a high school kid during the summer comes in. You just want to give them a job. They're happy to, make $8 or $9 an hour, just kind of sweeping up, cleaning up around the place. If the job order included things like, we'll also perform general farm duties, or we'll involve cleanup, anything that they say, well, that sounds kind of like what this guy's doing, even though that's the only thing he can do. They've taken the position, well, now, instead of paying him $8 or $9 an hour, you have to be paying him $12.38 an hour. That's something that we're trying to get corrected, to go back to the original intent, that basically they're doing the same job and are coming into it with the same skills and the same abilities. Arriaga, this is a little bit technical, that in the H-2A regulations, you're required to reimburse inbound travel after the worker's completed 50% of the contract. The idea being that if you paid them up front, there's a good chance that some of these workers will, take the free, airplane trip, bus trip, show up there and then take off, and you never see them again. They're paid up front and they're gone. The idea of them working half of the contract was to kind of get that commitment that they're getting this travel in exchange that they're going to actually do the work that they said they would. There was a court decision out of Florida that said, well, that's fine, the H-2A rules say that, but we believe that if the worker pays their own way, that lowers their effective hourly wage below the minimum wage. So essentially, even though the rules say pay at the halfway point, we're saying pay in week 1, in that first pay period. That's something that they're looking to change. And essentially just streamline processing. There's a number of executive orders have already come out, have been all over the news, the travel ban, building the wall, things of that nature. There was a leaked one that was sort of floating around the internet from probably about 3 weeks ago, shortly after the inauguration. Has not been released formally yet, but there was a draft that was around that talked about the H-2 program, the H-2A program in particular, about streamlining processing there and kind of improving program efficiency, but maintaining the kind of the integrity of the program. So the executive order wouldn't actually make those changes, but just expresses kind of an intent to move to that. And then an expansion of the temporary or seasonal idea to basically cover dairies and some of the processing side of it. Those have been discussed in the last couple of Congresses, but there's actually a chance of that moving now. On the Affordable Care Act, basically everyone's in kind of a wait-and-see mode. These are some of the general rules, and we discussed some of this on the earlier webinar. Essentially, kind of until further notice, the repeal process is underway, but it could take months or years. So, give out those exchange notices that you can find on the DOL website. Continue to file your 1095 reporting if you do offer coverage. Go through all of the things you normally would have last year until we find out that it is formally, dead, buried, and we can move on. But until then, all the laws remain in place for the time being. Immigration enforcement is a particularly hot topic. For the I-9 process, you need to do that for every new worker, every new hire. There's a new form that took effect January 22nd. You need to be using the new form for any new hires. That's available on if you go to USCIS, U.S. Citizenship and Immigration Services, uscis.gov, you can find that, or if you just Google I-9, they'll have the new form that you're meant to use. It's intended to be more computer-friendly, that you can fill out on the computer in the office. It has pull-downs, an option to kind of use a calendar to kind of pick the exact date when the worker started or when a particular driver's license or document is going to expire, things of that nature. But for all new hires going forward for this season, make sure that you're using that new form. We always tell people when you complete the I-9 that your job is not to be a forensic expert. This is not CSI, where you have to go through and, check the details. If somebody presents a document to you that looks valid on its face, you have to take it. If you push back and say, I don't know, I think I'd rather have X other document from you, or I need only passports, or I need LPR cards, green cards from people, that will put you in trouble with the Department of Justice. They now call it the Immigrant and Employee Rights Section, about kind of asking for more documents than are required or asking for particular documents. We've seen an uptick in enforcement from them and significant fines that come with that. And then for DACA, these are kind of the dreamers, kind of people that came as children with their parents illegally. They've had work authorization for a while. That was on the campaign trail. That was something that the president was going to get rid of on, quote, day one. We're on day 26 now, and they still haven't, because essentially the argument was made, these are people that came forward to comply, they put themselves out there, and now the concern is kind of pulling the rug out from under them. We'll see what happens with that. For now, if they have valid work authorization that they've shown you, that's all you need to know. Immigration enforcement, some of these people are, known to be hardliners. They're pushing back on this significantly. We've already seen in the news in the last, say probably 8 to 10 days, a significant rise in kind of ICE raids, where they will come into a community, round people up, lead them away in handcuffs. You will remember kind of late in the Bush administration, this is going back to say 2006 to 2008, about 10 years ago, that was a big practice. They would pull up to meat packing plants, some farms, but more food processing places, and just lead off 200 people in buses. That's it, they're gone, and then the employer's left to figure out what to do. There's a switch to moving to what they call as silent raids or desk raids, where they would look at people's I-9 forms, and then there would be a lot fewer arrests associated with that. If they found somebody they thought was undocumented, the employer would just sort of let them go, and then presumably they just go pick up with a different employer. But it was met with significant fines. It went from probably $30,000 or $60,000 in fines for the whole country late in the Bush years to was up to $16 to $20 million in fines per year, sort of in the latter half of the Obama administration. Some of this it's not just what the changes are. Some of the executive orders have talked about reprioritizing different aspects for deportation, including if someone is charged with a crime but not necessarily convicted of a crime, that could subject them to deportation. Generally speaking, again, you assume that all of your workers are legal, but just it's good advice to tell people, if you're driving, make sure your taillights are working. Have a license with you. Don't do anything that's going to kind of put you, on the map as far as the police are involved, that could eventually lead to, removal from the country. Just sort of having people be careful on things like that. And, the kind of handshake understanding that agriculture had with the previous administrator of Immigration and Customs Enforcement left when he did. So people in the ag community are trying to reach out to General Kelly and some of the people at Homeland Security to try to say, we understand that you need to enforce the laws, and we fully respect that. This is what that might mean for agriculture if it's not handled correctly or delicately, and just to kind of make that approach. And then sort of the elephant in the room that's been out there is this idea of mandatory e-verify, which, again, say for the other coast, for California, if that went into effect, they would lose probably 2/3 or 3/4 of their ag workforce overnight. These are people that could not survive an e-verify audit. It's been introduced. It's also been introduced in essentially every Congress for the last 10 or more years. So, but in the current climate, there's the chance that something like that could actually move forward. For employers, they're trying to connect that to improvements to a visa program. Say that if you're going to do that, give us an opportunity to hire people legally and use H-2A or H-2B legally and expand the capacity there, because people want to follow the law, but if you just say we're taking away your workers and we're doing nothing to kind of find new workers for you, that's a recipe for people losing their businesses. So that's just as a heads up that's on the table, something to keep an eye on in Congress, but so far hasn't happened yet. For OSHA, this is the same rule. It's essentially the reporting rule. These are some of the things that we would expect that the new DOL, once they can actually get a labor secretary confirmed and sworn in, would take a look at under this idea of one reg in, two regs out, basically, taking out old regulations, that there can be some streamlining and some pruning back of some of the worksite safety issues for OSHA. And again, the general advice, just be prepared, know your rights, be ready. If you're going to go into the H2A program, go in eyes open, know what to expect, have everything in order, and just having good record keeping. Documents are your friend. If you don't have a record, DOL will ask the workers and they'll say, I think I work about 70 hours a week every week, and then that's what they're going to say you owe them. But if you have records that show, no, this is when they clocked in and out, they worked about 45 hours a week and that's what we paid them for, you can actually survive an audit without having to owe money. And so that's the good news. I'd like to throw it open if there are any questions out there. We'll save some time to try to talk to folks. Anything that you're interested in, or any confusion or questions?
Well, great. Thanks, Chris. Yes, we have had a few questions come in, so I'm going to start leading through those. Just as a reminder for folks out there, if you do have a question, the GoToMeeting webinar control panel, if there's a tab on there for questions, you can type that in. We'll try to get to as many as we can before the top of the hour. So, Chris, I'm going to go lead off going back to the DOL overtime rule. You'd mentioned that the court had blocked that prior to its implementation in early December. This is a little bit of a process question, but I think it's important because it might apply to other rules that are out there. That was a final rule, as my understanding is. So I'm just wondering, in terms of the process of, if, say, the new Trump administration wants to come in a sense, undo that rule, how would that differ as if it was still in the middle of the rulemaking process, like a proposed rule?
Yeah, there's sort of two ways that we're seeing where they are rolling back or undoing rules. Usually in the media they'll just sort of use that shorthand for it, but it kind of depends on where they are in the process. If it was a proposed rule, the rule had not gone final before the last administration left, then they can essentially shut that down or not issue the final rule, or issue a different final rule if they want. For something like the overtime rule, they basically have to replace the rule, they have to go through the same process that the previous administration had used to put it into effect. So they would have to issue a notice of proposed rulemaking, leave it open for public comment, consider those comments, and then publish the final rule at the lower level. For this, where there's a court injunction against this new rate, the predecessor rule would still be in effect. So they can block a particular rule, they're not allowed to enforce that. So it's still technically on the books, but they're not allowed to enforce it. Congress can do the same kind of thing by saying, we are funding your agency, here you go, Department of Labor, here's your money, but you're not allowed to use any of that money to enforce the following rules that we don't like. So they're still on the books, but Congress can't go out and audit and enforce that. That's in place right now for a number of parts of the new H-2B rule for non-agricultural workers, that they simply can't enforce parts of it, and so it's as though it's not there. Eventually they could get funding for it, and that would be, then they'd be up and running again, but there's ways that it's blocked. And then the other way is the Congressional Review Act, which has been on the books since, I think, when Newt Gingrich took over back in the mid-90s, has only ever been used successfully one time, where Congress will pass what they call a notice, disapproval notice, basically, that will strike down a rule. If both chambers, House and Senate, sign it, and then the President signs it, that wipes out the rule, and it prevents the agency from ever issuing a rule on that subject again. The House has passed, I think, 6 or 7 of those already, and they have a couple more on today. The Senate has not taken any of those up. So there are different ways that they can kind of kill these old rules, but the main way is to issue a new rule to take its place, and that will take months, where they kind of put it out for 30 or 60 days of public comments and then issue the final rule after that.
Okay. And kind of staying on that topic, because as the DOL overtime rule relating really to white-collar professionals, one of our participants had texted in that New York State actually has put in its own regulations for a higher level. I didn't compare the numbers. I think it was $727 per week. So I think more similar to what the new federal rule was going to be. And I was just wondering if you see if you've seen other states taking this type of action, especially now in light of the fact that the revised federal rule is in question.
Absolutely, yeah. No, that's especially for just the base level of minimum wage. We saw that a number of the states in the Northeast have just moved up their own effective minimum wage, so that just takes the federal off the table, because if you're required to pay $8.60 or $9.70 an hour, it doesn't, and you paid $7.50 an hour, you're complying with the federal, but you're out of compliance with the state, so that does you no good. So basically, the kind of inaction on this at the federal level has moved a lot of states to do that. And then in ag in particular, California has recently moved to implement overtime for agriculture. Minnesota, I believe, is already doing that. That's something we could see state legislatures start to take up. So they would have something that is, not necessarily going as far as the Obama Department of Labor would have done, but kind of certainly moving the ball forward in some of these more progressive, more liberal states. For New York, I think it's $4.55 per week under the existing white collar overtime rule. They wanted to move it to over 900, so the 700 is kind of splits the difference, but it's still a significant increase for New York white collar workers. But that's where in the state legislatures we expect to see more of that activity if the U.S. Congress doesn't move on it.
Okay, great. Someone asked about the documentation, a couple questions related to I-9s and the documentation that's required. One relates to someone who might have the documentation but does not want to provide it in terms of, for whatever reason, in terms of staying under the radar for various reasons. What would you advise in a situation like that?
Yeah, no, I mean, there are different reasons why people might not want to, and I don't think you necessarily can draw an inference as to, their work status. But that said, the rules are that you need to complete that within 3 days of when the worker starts working. Again, don't ever, prepare an I-9 before they're hired. Don't pre-screen people to see if they're legally authorized. But when you make the offer to hire them, you need to complete that almost, essentially immediately in the first day or two to get them on the books. If they don't provide the records, you can't hire them, period. That was the change in 1986 under IRCA. I had a grower out west who had, they had hundreds of workers over a few years. They were audited. The only one that they found, somebody that had come in, knew that they weren't going to check until day 3, so worked for 2 days, and then took off, and had only presented them an expired document. They knew it was wrong, and it told them, look, you need to bring in the proper documents. They were fined, several $1,000s for him. That essentially, that if they're working after that 3rd day and haven't provided you with the documents, now you're liable, and the penalties have been increased in the last few years. So you're at significant risk for doing that. I mean, you're being nice, you're giving somebody an opportunity to do the work, but the government won't see it that way. They'll say that you're employing people illegally, and there will be significant fines for that. And part of the concern is that this is somewhere where they could ramp up enforcement. There are a number of enforcement penalties that are on the books and just haven't really been used in the last 30 years very much. There's something called a pattern or practice of violation that if you employ a number of workers, the Department of Justice can come in and treat that criminally, so people could do jail time for that or face extremely significant penalties or forfeiture for that. So that's on the books, hasn't really been used that much, but under Attorney General Sessions, who's been very strong on immigration enforcement, it's not impossible that people could start to see those more serious penalties come out.
And that's a good segue to a question that came in on penalties about who actually gets fined in the case of a finding on an I-9 audit. I assume that's the employer, and that doesn't flow back to the employee.
No, that's exactly right. So, and there are two things. I mean, this sort of completing the I-9 incorrectly. I mean, you could have a worker whose ancestors came over on the Mayflower. They've been here for 40 generations, have lived here forever and ever and ever. There's no question that they're legally authorized to work. But if you filled out their I-9 improperly, the employer still pays a penalty for the paperwork violation. Or on the flip side of that, you could fill out the I-9 perfectly with the documents that they provided, so the employer there would owe no penalty because they've completed the I-9, they've done their obligation 100% correctly, no penalties owed, but they're still notified. We believe that this worker is not work authorized. They get what they call a notice of suspect documents, that what look to be valid, that Social Security matches to a grandmother in Duluth and not to this person's name. Then you give the worker an opportunity to correct that or to get it sorted out. You ask the agents that come through from Immigration and Customs Enforcement for a reasonable amount of time to clear it up so that you're not prejudging anybody. You give them fair opportunity, and if they don't, you're required to let them go. Because after that time, now you knowingly, and that's the hook, is that you know that they're undocumented or not work authorized. That's when the employer would face the penalty. But in that scenario, it's possible the employer would not pay any penalty. They would just let the worker go. The worker wouldn't necessarily be deported. That's a totally separate process. So it could be that you just sort of part ways, no money is owed.
Okay. A couple questions came in on something prior to the webinar that we had exchanged emails on, which is, given the stance of the new administration relative to comprehensive immigration reform, there has been some talk that, well, maybe there's an opening for a guest worker program, and kind of a corollary to that is, could a program like H-2A be expanded to allow for year-round workers? I know that there's a proposal in Congress from Representatives Stefanik and Collins in New York to do just that, as well as potentially moving it to the Department of Agriculture. So just wanted to get your take in terms of what the likelihood would be there, and maybe the pros and cons to, say, putting in a new guest worker program versus reforming H-2A.
Yeah, no, and I think that those bills are some of the first ones to be introduced, and I know that there are other offices. We were on the Hill last week, meeting with different offices on this issue, that other offices have not yet introduced them but are interested in doing so, and that ranges from, very kind of rifle shot narrow fixes of saying, hey, Department of Labor, if you're going to send notices on H-2A, do it by email instead of by snail mail, so that people will have that notice and can respond to you more quickly. You'll save days on the front end. Fairly small kind of quick fixes like that, to we're going to just tear up the program and start from scratch and go to something that is not just contract-based but an at-will program where workers can come in and they can move between employers during the season, basically kind of redrafting it from scratch rather than, making, minor adjustments to the process that's been there and mostly unchanged for the last 30 years or so. The expansion to year-round and to dairy would be a significant one. There's a huge demand for labor in dairy right now that is not being met with the existing workforce, and possibly not, of the workers that are there, there's a concern that they may not all necessarily survive an E-Verify check. So that would be a significant change. That would be on the larger end. I think right now there's kind of, a lot of the offices there's kind of a wait and see attitude, that there's a sense that immigration is a little bit too radioactive right now to pick up, to make changes on that, with some of the executive orders that have come out, and the blowback that's come from that. There's a sense of kind of let's hold back and kind of have these discussions and see what we can do. We've reached out to people, in the White House, people in the agencies, people on the Hill, to try to see what can be done within the agencies to make the program work better. I think part of the concern is that as individual groups come in, if they ask for small fixes that will help their problem, then when the larger group comes back, the Congress will say, well, no, we already fixed it. We gave these guys, this little fix over here. Why are you still talking to us? So the idea is to kind of make sure that we can actually get something that works for everybody, but at the same time not so big that, perfect becomes the enemy of the good, and so, no change moves through. So try to find that right combination of changes that will make the program appreciably better, because you only get so many bites at it to kind of come into them and make that big change. Is kind of a once-a-generation change. That basically, usually about every 30 years or so, they'll have a big change to the program. So, find what can work for as many people as possible, but something that can actually move through. And that's where people are trying to work out right now, is finding that balance. But some of the proposals, I think, would make the program significantly better, as far as speeding up processing, moving it to USDA, whose interest is in obviously producing agricultural commodities and not in running basically organized labor's agenda. So there's sort of a difference in approach there. That's been a consistent thread in a lot of the proposals, is move it over to USDA and find ways to bring in other parts of agriculture under the tent of the program.
So just time for, I think, maybe one or two more here. Appreciate the questions that have come in. May not get to quite all of them. Quick clarification on the secondary ag overtime exemption rules as it relates to office staff. Maybe you could touch on that one again. I know,
sure.
I know there we get competing exemptions going there at that, when we get into that area.
No, and it's one of those topics that if you ask 3 lawyers, you get 5 different opinions on it. So it's it depends a little bit on the specifics of the operation. It's a slightly more aggressive approach, but one that I believe that generally, if your office staff is working on your farm and working just for you, and the work that they're doing is purely to cover people that are themselves exempt, so they're just writing paychecks for other people that are already ag exempt, I would take the position that they are themselves ag exempt. There are old cases on this for people that are not doing any of the farming work but are doing support work on the farm. There's one involving a railroad on a sugar plantation in Hawaii, and there's one involving kitchen staff where they're preparing meals for the farm workers. I mean, they aren't doing anything that looks remotely like farming, but because the work is there and is essential to the work that the farm workers themselves are doing, they were treated as ag exempt in those cases. The argument that I would say would be that this is analogous to that. Even though they're working in an office, the work that they're doing is essential, incident to or in conjunction with the agricultural work, so they could take the position that that work should itself be exempt. Not everybody would necessarily agree with that, and it may be something that's kind of one of those areas on the margin where you could get a wage and hour investigator that would push back on that, but that's one that I feel like you could fight if they did.
Okay. This last one, and the question came in relative to, I think some of these things, were in the context of ag employers. And obviously, part of this too is, protecting the immigrant workers as well and their rights. One of the questions came in relative to providing a valid driver's license. It's kind of a specific one, but maybe you can generalize the response on this. A valid driver's license and a Social Security card, which says valid only with DHS authorization. But so would that employer be required to get or view the authorization card before they can accept that documentation?
No, and this is coming up with, there's something called the Real ID law that certain documents can't be used to basically to enter federal buildings or maybe to travel on airplanes, things of that nature where DHS or there's a security feature where they're looking at it. For the I-9 process, you're using the driver's license solely to establish identity. There's list A documents that establish identity and work authorization. That's going to be something like a U.S. passport. So it has a picture, this is the person presenting it to you, and it's a document that says this is a person who's a citizen because they have a passport. More often people have a list B and a list C. So B would be, it could be a student ID. Sometimes they'll take a fishing license. There are different things that just it's a government issued document that has their picture and their name, so this is the person that's showing it to me. And then a list C would be like a Social Security card or birth certificate or something like that that shows that they are, either born in the U.S. or otherwise authorized to work in the U.S. So the DHS requirement is, I think, specific to those other kind of security features, but is not necessary to establish their identity. The concern is, when they're issuing those, does that create enough suspicion in your mind? Well, why would somebody have this if they were a citizen? That's strange, so that it starts kind of raising questions. That, I don't believe, is enough to establish what they call constructive knowledge. Actual knowledge is the person says, I am not legal, or presents a document to you that shows that they were born in another country and are not authorized to work here. Okay, now you actually know, or the government tells you, we've audited them, we ran it through, we verified, they can't work in the U.S. Okay, you actually know that they can't. Constructive knowledge is you have enough suspicion built up to say a reasonable person would know that they're not authorized. I don't think that's it. I think that there are different reasons why somebody would have that document that are not specific to them being not work authorized. So you can use that to establish their identity. And then if they have a social security card with them, then you can use that to say, well, that says that they're work authorized. So it's a closer call, and it raises some questions. And this is where employers need to be careful, when they're talking to people that have DACA status or different things like that. A lot of these conversations you don't want to have with your workers. You can say, look, if generally speaking, I assume that you're all legal, but if any of you want to go talk to people, here are some legal services groups that you can talk to about, say, cousins or family members you have that might not be legal. But again, I assume that you all are. You don't want to get into that conversation where they're telling you, volunteering information that you shouldn't have. There's an article in the New York Times last week that identified a farm worker as illegal and said where they worked. Well, now that farmer knows that he has an illegal worker, and he had to fire him, and he'd been a crew foreman there for 20, 30 years. But once that's out there, that you have that actual knowledge, that's it. You have to let them go. So kind of there's a certain head in the sand aspect to it, but at the same time, if they've presented documents, you've done your part, and I think this specific document should, establish identity and kind of serve its purpose in the I-9 process.
Chris, we appreciate your staying with us. We obviously covered a whole range of issues here, and again, appreciate being able to borrow from your expertise and get your thoughts on it, so appreciate your joining us. And we appreciate everyone for attending. The recording of this will be available at farmcrediteast.com/webinars. Thanks for attending.